Thank you, Madam Deputy President. I rise to speak for the opposition on this bill and indicate at the outset that we are opposing it. This is not because we are unsympathetic to its aims. Any legislation whose purpose is to advance equality for LGBTIQA+ persons in New South Wales is laudable and deserves careful consideration. The problem, as always, in dealing with legislation concerning rights is how well it balances the legislated rights with the rights of others in the community. And in this case, considerable concern has been expressed by members of the community about the balance point of this legislation and the impact on women in particular. My colleague in the other place has considered the legislation in detail and discussed the problems we found through that consideration because of the late provision of the many and varied amendments, all of which are now part of the bill to be considered by this House. It is not my intention to revisit this discussion, and I acknowledge the beneficial nature of many of those amendments. I also note that I will not be surprised if we see this bill, should it be passed, addressed in a future miscellaneous provisions bill to address what appears to be some inconsistencies. I wish to focus my remarks on three key areas of the bill and outline the difficulties which arise. The first of these are the changes in relation to the provisions in the Summary Offences Act in relation to prostitution. The original Schedule 18 of the bill proposed to delete Part 3 of the Summary Offences Act, which deals with prostitution. Now, members will know, and indeed the Honourable Member has just reminded us, that prostitution is not illegal in New South Wales. This was not a proposal to decriminalise. Rather, it was to repeal a number of provisions, many of which were designed as protections for the largely female sex workers in this state. I recognise the positive amendment introduced yesterday, which now retains Section 15A, which will continue to prohibit a person coercing another into prostitution. In the second reading speech introducing this provision in October 1995, the then Attorney-General, the Honourable Jeff Shaw QC, said that Section 15A, and I quote, would include, for example, the offering of heroin to a heroin addict so that he or she engages in an act of prostitution. This provision is also capable of ensuring that the exploitation of young women in particular does not result from the recognition of brothels as legitimate commercial enterprises, end quote. That this important protection will be retained is positive. However, the bill still seeks to repeal Section 15 of the Summary Offences Act. This prohibits a person living off the earnings of prostitution. The reason for deleting this provision given by the member for Sydney in his second reading speech was, quote, there is an offence for knowingly living off the earnings of sex work, with adults living with a sex worker who do not have other sufficient lawful means of support specified. The offence could incriminate a sex worker's partner who becomes incapacitated, an adult child who lives at home while studying, or a housemate on a low income, end quote. Mr Greenwich hypothesises that it could incriminate dependent family members, but the reality is that it has not and it does not. Mr Greenwich was unable to provide me with details of anyone fitting his criteria who had been charged with a breach of Section 15 in the last 5 years. And this is because Section 15 is correctly characterised as an anti-pimp provision, not an anti-family provision. Living wholly or in part on the earnings of prostitution of another person means taking some or all of the earnings at or shortly after the act of prostitution. It does not capture a person who shares the groceries and the household of a sex worker. Living off the earnings is criminalised because it is usually part of an unacceptable pattern of coercion to which prostitutes should not be subject. In introducing subsections 3 and 4 of Section 15 into the law, the then Attorney-General, the Honourable Jeff Shaw QC, said, quote, living off the earnings of prostitution requires a continuous association with the prostitution industry and habitual receipt of money from the earnings of prostitution, end quote. None of the domestic relationships cited by Mr Greenwich in his second reading speech constitutes a continuous association with the prostitution industry. There is not a business character to the domestic relationships that he uses in his examples to justify the amendment, because their receipt of money is by reason of a voluntary payment and has no commercial character in association with the industry of prostitution. His aim is clearly to protect sex workers from unwanted intrusion by the law, but the repeal of this section would have the opposite effect. It leaves prostitutes vulnerable to others who would exploit them commercially. It is not justified and it should not be supported. And I am frankly amazed at the support provided by Premier Minns and the entire Minns government to this bill. Their Labor colleagues 30 years ago could understand the vulnerability of women, men and trans people working in the sex industry and legislated a protective framework to provide some recourse from coercion and financial exploitation. This Labor government, which talks the talk of workers' rights, is now involved in the dismantling of protection for sex workers, the very protections introduced by their Labor colleagues. By supporting this bill, the Minns government is supporting the removal of protections which guard against the exploitation of vulnerable women, men and trans people engaged in prostitution. The next issue I turn to now is birth certificates. Schedule 1 of the bill as amended deals with changes to the Births, Deaths and Marriages Registration Act, and in particular to the sex recorded on the record of a person's birth. It proposes a new administrative process to change the sex on a birth certificate record for people born in New South Wales, which does not require any medical or surgical intervention or any evidence of counselling or psychological support, except for minors who wish to transition. I rely on the Shadow Attorney General's close discussion of the provisions yesterday and wish instead here to address some of the arguments which have been raised in relation to our opposition of this bill. The first argument we keep hearing is that we need to align ourselves with the position in every other state. Interestingly, this argument is only made in relation to birth certificates and is not considered by those who are also supporting the commercial surrogacy provisions of this bill. Because if this bill does pass, then unlike every other state in Australia and the Australian Capital Territory and the position taken by the Commonwealth of Australia, we and we alone will be facilitating commercial surrogacy. But putting that to one side, how do we compare to other states? In South Australia, an individual seeking to change the sex descriptor on their birth certificate must have received clinical treatment provided by a medical practitioner or psychologist. This does not require surgical intervention, but treatment, and hence discernment, must have continued for a period of at least 6 months. At that 6-month point, there is then a consideration point where the medical professional must certify that the person has undertaken a sufficient amount of treatment and truly considers themselves to be of the sex they are seeking to be registered. I note that unlike the proposal in New South Wales, both sex and gender identity are recorded on South Australian birth certificates. Applications in Western Australia are currently subject to sections 3 and 14 of the Western Australian Gender Reassignment Act 2000. This requires that before a person can be issued a recognition certificate of another sex, that person must have undergone a reassignment procedure. That is defined as a medical or surgical procedure or a combination of such procedures to alter the genitals and other gender characteristics of a person identified by a birth certificate as male or female, so that the persons will be identified as a person of the opposite sex. This is subject to change, but the law which will affect that change has not yet been proclaimed. And even when and if it is, much more will be required than our suggested application to a registrar, supported by a note from an adult friend and the ensuing administrative process. Western Australian applicants will need to proceed by way of an application to the Gender Reassignment Board, and that board must be satisfied of the following 3 things: that the applicant believes that their true identity is the identity to which they have been reassigned, that the applicant has adopted the lifestyle and has the gender characteristics of a person of the gender to which the applicant has been reassigned, and that the applicant has received proper counselling in relation to his or her gender identity. Importantly, this does not change the birth certificate, but issues an acknowledgement document which identifies the person's gender and also their sex. In the Northern Territory, there is a requirement that to change the record of sex on a person's birth certificate, an application must be made to the registrar, and this application requires evidence that the applicant has undergone appropriate counselling, hormone therapy or surgery. Tasmania, Victoria and Queensland, as of June this year, have systems similar to that which is proposed for New South Wales. So it is perhaps more correct to characterise this change as seeking to align us with half the states, and our procedure for changing sex would still become one of the most permissive in Australia, requiring, as it does, only administrative procedures and no medical treatment or counselling to support the transition. In fact, our legislation will not even require a person to have lived as the intended sex, just to have expressed a desire to live as that other sex. What I find remarkable about this change is that it minimises the journey undertaken by a person changing their sex. An amended birth certificate used to be available at the end of that journey, and some have argued that we had that milestone set at too high a point, with the requirement for a complete surgical transition. I acknowledge that argument. But are we now completely overcorrecting and trivialising the huge decision and the major journey of those who embark on the process of transition? Instead of an amended birth certificate being available at the end of the transition process, it will now be available as a first step for someone who intends to live as the other sex. Consider the situation of a person who obtains a new birth certificate identifying as a different sex without having taken any steps on the transition process other than forming an intention to change. If that intention, once tested, changes, what then? We may have had the bar set too high, but have we gone from pole vault to limbo? And I have been deliberately using the language of different sex rather than opposite sex, because this bill seeks to change our long-held understanding of the binary nature of sex, XX or XY, to a more fluid approach and allows a range of other sex descriptors, such as non-binary, on our birth certificates. This is indeed a significant change, and is one of the reasons why this bill has been accused of conflating sex and gender, an argument considered in detail by my colleague in the other place. We've also heard the argument that to oppose this legislation is to be anti-trans. To accept this argument, we would have to accept the proposition that unless every proposal concerning one particular community is accepted without comment or amendment, one is opposed to this community. That proposition is illiberal in the extreme and would destroy our multicultural society. We have the benefit of living in a diverse community where we work hard to balance the rights and desires of one against the rights and desires of others. That balance point is often difficult to achieve, causes tension, but is necessary for a healthy and inclusive society. It is the opposite of a society composed of a number of separate monocultures. Our opposition to the changes proposed is not anti-trans, but rather a consequence of the many unanswered questions as to the implication of these changes and our concerns about how and if the right balance has been struck across the entire community. The opposition is not anti-trans, and to argue this is simplistic and reduces important and nuanced discussions to juvenile slogans. When the Coalition was in government, it introduced for the first time into the Anti-Discrimination Act, Part 3A, which introduced protections for trans people. We proudly stand on our record. Another argument that we hear is that this change is about recognising trans people, not about women and women's spaces. This issue is at the heart of opposition to this bill, and is the issue which has dominated inboxes and telephone calls across this parliament. This is the issue which is concerning many women and men, and this is an issue which deserves respectful consideration and not a disrespectful dismissal as a turf issue, no need to consider. And this issue is actually about both of these propositions: appropriate recognition of trans people and appropriate recognition of women's spaces. And so the question is, have we arrived at the right balance point? And our answer is no. A birth certificate is a public document. It is outward facing and is how we are known and identified by the world. We use it for a host of purposes, and at least some of those concern how we interact with others. We all have memories, if not current experience, of lining up at soccer and netball registration days with birth certificate and registration fee in hand, and in the days of the Coalition, the Active Kids vouchers, which were so important for all parents in addressing the high cost of living. This proposal has raised such significant community concern because the practical effect is that persons with the biological body of a man but who identify as a woman may, without any surgical change to their bodies, legally become a woman and are likely as a consequence to have access to female-only spaces such as swimming pool changing rooms, showers, play female sport, reside in female refuges and be housed in female prisons in a manner that they currently cannot. This has been the experience in other jurisdictions where similar changes have been made, and so we should expect it to be the experience in New South Wales if this bill passes. The amendments have attempted to deal with the situation in which some of the worst interstate and overseas abuses have occurred: correctional facilities. New Division 5A prohibits prisoners from making applications to change their sex during the period spanning remand to release. This protects against opportunistic attempts to change sex and provides some protection to female prisoners. However, it does not address the situation which has arisen, for example, in Victoria, where a trans inmate who had begun transition prior to arrest, with a history of violent assaults against women and a functioning penis, was incarcerated in a female prison, much to the concern of other female prisoners. All of the voices in these issues deserve to be heard. I also note with thanks that one of the amendments, the new section 32H subsection 4, includes the provision that this section is subject to any other act. This aligns with provisions in other states and will be protective where there are existing statutory regimes which clearly need to be read in relation to sex characteristics. However, where access, for example, to gyms or changing facilities is contractually based, this will not assist in the protection of female-only spaces. So the issue remains, especially for change rooms and sporting teams and other areas of life regulated by club membership or contract or terms of entry set by private owners, that if a trans woman has a female birth certificate under these new proposed provisions but has undergone no medical, hormone or surgical process, then it will become difficult and perhaps in breach of Part 3A of the Anti-Discrimination Act to treat them as anything other than female. And legalities aside, it will be very difficult from a practical point of view to go behind a birth certificate which says that the person is a woman. This could create significant issues for single-sex schools, including boarding schools, change rooms, sporting teams, women's refuges, correctional facilities. There are interstate and overseas examples where the presence of biologically male bodies in female spaces has created dangerous situations for some women, a situation which we hope will not be repeated in New South Wales. But I note that this legislation contains no effective measures to prevent this. The proposed new section 32H states that any change to the sex record under this part means a person is legally of the sex that has been changed. However, a note to the section recognises the problems potentially created by this change and makes a half-hearted attempt to address this by stating, nothing in this part changes access to toilets, change rooms, sport allocation in correctional facilities, women's refuge or any other place. This is a note. It has not been included in the legislation as a section. It has no operative effect. And Section 35 of the New South Wales Interpretation Act specifically says that notation such as this shall not be taken to be part of the Act. At best, it could be used as extrinsic material to interpret the provisions of this Act if the threshold tests in Section 34, subsection 1 of the Interpretation Act were also met. And extrinsic material is used to interpret the meaning of the provisions of an Act. And the issue here is not their meaning, but their impact on women's spaces. I am not sure what is worse, to just simply ignore or sideline the impact of these provisions on women, or to recognise, as this note does, that these problems exist, to recognise the impact of these provisions on women, and then make a token and totally ineffective attempt to engage with this important issue. And let us be clear, this bill may have begun as independent legislation, but it has been completely adopted by this government. Ministers of the Minns government stood at a press conference with the member for Sydney expressing their support for this bill. The Minns government suspended standing orders in the other place and in this House to facilitate the passage of this bill, and the Minns government is supporting this bill, including its deeply flawed attempt to deal with the issue of the conflict between these provisions and the maintenance of women-only spaces. Much has been made of the number of women currently sitting around the cabinet table. But if they are not listening to the voices of women, if they are not speaking up for the needs and interests of women, if they have not raised the concerns of women about this legislation, then their mere presence at the table is no guarantee of female-friendly and truly inclusive policies. Indeed, their support of this bill indicates the complete opposite. There will be legal issues arising out of this bill, issues about the operation of various provisions of the Anti-Discrimination Act and certain provisions of the Summary Offences Act, and these will no doubt be addressed by courts and other tribunals over the coming years. And I do hope that our law allows us to arrive at a different space than Tasmania, where a lesbian social group was prohibited from excluding lesbian identifying but biological males from attending their functions and attempting to court their members, often to the distress of those women. I want to focus on the likely effect of this legal change on the behaviour of women, a behaviour with which we are all too aware. Self-editing, which means we stay away from spaces which feel unsafe, don't go out to certain areas, hold back from engaging in particular activities, or don't fully engage in society. I want to focus on why so many in our community are opposed to this legislation. And I note in this respect the work of the Legislative Assembly Committee, which conducted an inquiry into this bill on behalf of the Parliament. They surveyed over 13,000 people in relation to this bill, 85% of whom rejected it in its entirety. And given that fewer than 1% of respondents said that they would support it if it were to be amended, it is unlikely that the recent amendments have moved this needle at all. And indeed, my inbox and the inboxes of all of my colleagues, and I suspect the entire House, are evidence in support. I note also the more than 25,000 signatures on a petition received by this House opposing the introduction of this bill. These are significant voices, many of them female, which appear to be unheard by the Minns government. Voices like those of a 14-year-old girl who likes to swim and is prepared to train hard. Her mother drops her at the pool early each morning for squad and then picks her up, changed and ready to be dropped at school. Except now there are new bodies in the change room, bodies that are anatomically male, bodies that are stripping and changing when she is in the dressing room, and she is confused and uncomfortable and stops swimming. Like so many other women have done over the years, self-edited their participation in public life. And girls and young women playing soccer, choosing a women's competition rather than a mixed comp, who find themselves playing against a number of women who have undergone male puberty and as a consequence have stronger, faster bodies, and these women self-edit. They drop out of playing community sport. We have already seen examples of this, with women's teams choosing to forfeit in certain Sydney sporting competitions rather than play their stronger competitors. We have separate male and female sporting competitions for a reason. Those who have undergone male puberty have developed different bone structures and musculature than women, and are usually stronger and faster as a result. By way of illustration, the women's 100, 400 and 800 metre running records are beaten by literally hundreds of men each year, including by many high school boys. The qualifying time for the 50 metre freestyle in the Paris Olympics was 3 seconds longer for women. These times recognise biological fact. It may be that we need to develop a new paradigm for sports and other areas of life to truly accommodate all those in our society. But simply saying to women, your paradigm has to change, is not the answer. Yet it seems to be the message of this legislation. This discussion should not be interpreted as an attempt to exclude trans people from participation in sport, but nor should this legislation be allowed to foster self-exclusion by women and girls from sport. This is lazy legislation, which is not engaged with the difficult issue of how we can accommodate the needs of all in our society. This is legislation which should be called out for recognising the challenge it presents to female spaces, but failing to adequately address appropriately this important issue. This is legislation which should be rejected because it does not get the balance point right. That 14-year-old would-be swimmer and her mother and her grandmother want to see women able to participate fully in every aspect of life. We have fought for years to ensure that women are recognised and that full participation in every aspect of society is possible. We have 50% female representation in Cabinet, yet this government will preside over legislation which reduces opportunities for women to fully participate. This is shameful. I turn now to address the issue of surrogacy, and perhaps the biggest changes made by this legislation are those proposed to be made to our surrogacy laws. Currently, it is an offence under Section 8 of the Surrogacy Act to enter into a commercial surrogacy arrangement, punishable by a substantial fine or 2 years in prison or both. And according to the Australian Government website, Surrogacy Overseas, entering into an international commercial surrogacy arrangement in New South Wales is illegal and carries risks for the surrogate mother, the commissioning parents and the child. The 2018 statutory review of the Surrogacy Act did not recommend any of the changes contained within the bill proposed by the member for Sydney. The New South Wales Department of Communities and Justice is currently undertaking another review of the Surrogacy Act. Submissions have been lodged and stakeholders are being consulted. Any change to the Surrogacy Act should sensibly await the outcome of that review and should not be a piecemeal exercise of the kind proposed by this Minns Greenwich Bill. If the Premier had read his own government submission to the parliamentary inquiry, he would know that his very government argued that the current review process, rather than this bill, was the most appropriate avenue to consider any amendments to the Surrogacy Act. The government's argument was based on the complexity of the policy in this area and the operational landscape. And this landscape includes the complementary legislation in the ACT and all the other states, which prohibits commercial surrogacy and makes no measure to facilitate its operation. Schedule 12 of the bill contains the proposed changes to the Surrogacy Act. In essence, they establish a scheme to permit the making of parentage orders in respect of a child born as a result of an international commercial surrogacy arrangement. Currently, if a child is born as a result of a still illegal overseas commercial surrogacy agreement, that child receives a birth certificate in the jurisdiction of its birth, governed by the laws of that jurisdiction. Before that child can enter Australia with one or both of the commissioning parents, a passport is required. This is obtained by lodging a claim of Australian nationality by descent, usually by the biological father whose sperm has been used as part of the surrogacy process and so has a genetic link with the child. Once in Australia, an application is typically lodged with the family court for the making of a parenting order pursuant to Section 64(b) of the Family Law Act. And anyone who has gone through a divorce and needed to make arrangements for the custody and welfare of minor children would be very familiar with this process. This section allocates parental responsibility for a child to a person or provides that a person is to share parental responsibility for a child with another person. A parenting order does not change the child's original birth certificate, and if only one of the commissioning parents is listed on the child's original birth certificate, which is usual as the birth mother is usually recorded as the surrogate mother, a family court parenting order can provide acknowledgement that the commissioning parents have parental responsibility for the child, that the surrogate mother does not, and assist with accessing services such as Medicare and Centrelink and education. The test applied by the family court is the best interests of the child. I acknowledge that this is a cumbersome process and does not lead to the grant of a new birth certificate. One parent will always be off the birth certificate unless an adoptive process of some kind is pursued, and there may be many times when the situation of the child's birth may have to be explained. But it is simply not true that these children are in a legal limbo. They have parents legally recognised as responsible for them and a birth certificate which records their identity at birth. The changes introduced by this legislation are, at a high level, to remove the mandatory requirement for a surrogacy agreement to be altruistic before parentage orders can be made in respect of the child born as a result of the surrogacy agreement. This will facilitate the use of still illegal international commercial surrogacy arrangements. A parentage order is about changing the birth certificate of a child to record the child's new parents. And the legal difficulties of how this New South Wales law will interact with the birth registration laws of the foreign jurisdiction in which the child has been born do not appear to have been explored by this legislation. A parenting order is about caring for the best interests of the child and ensuring they have someone who appropriately cares for them. The proposed changes represent a major policy shift in our approach to commercial surrogacy and will lead to a rise in the use of commercial surrogacy in New South Wales without an adequate consideration of the associated risks. And these risks are very real, especially for the surrogate mothers. The New South Wales Modern Slavery Commissioner was so concerned about these proposed changes that he wrote of his own volition to the member for Sydney to raise the issue that too often the mothers in overseas commercial surrogacy have functionally no choice and are being used as slaves. In budget estimates last month, he said, and I quote, "Just to give this a little bit of context, this is not a purely abstract or hypothetical concern. In September 2023, so about a year ago, authorities in Greece raided the Mediterranean Fertility Institute and charged all of its staff members with participation in human trafficking after an investigation uncovered use of brokers, fraud and record falsification to traffic at least 98 women from the Ukraine, Moldova, Romania, Albania and Georgia, many of whom became birth mothers at the clinic. They targeted financially vulnerable women. Shockingly, around half of all the clientele for that institute were reportedly Australian. Between 60 and 150 Australian families are thought to have been impacted by this incident." End quote. So a clinic which Australian families thought was reputable and were using as part of their commercial surrogacy arrangements was using women trafficked in for the purpose of being surrogates. These women had no choice and they were likely receiving little, if any, of the relevant remuneration. This is exactly the type of risk which is the reason why every state in Australia and the Commonwealth have said no to commercial surrogacy, because we do not want to have children born at the price of slavery for overseas women. But this real risk is being ignored in this legislation. In response to the concerns raised by the Modern Slavery Commissioner, Mr Greenwich has suggested in the media that going forward there will be limits to prescribed jurisdictions, quote, "where commercial surrogacy is well regulated and the rights of the surrogate protected," end quote. But this statement by Mr Greenwich is not reflected in legislation. Mr Greenwich has acknowledged the issue of slavery, but has done nothing in the amendments to address it. In the 11 pages of amendments presented yesterday, there is not one mention of addressing the issue of slavery. With this real risk to women, how can we pass this legislation, which is designed to facilitate commercial surrogacy and thus drive up demand, further increasing the pain of some women? Or is it okay because they're overseas and we cannot see them? The Coalition will not stand by and facilitate slavery in any form, and we invite the government to do the same. Especially this government, which prides itself on its care and concern for workers and the need to establish safe workplaces. The Minns government, which has passed the industrial manslaughter legislation and the assaults on retail workers legislation to provide safe workplaces for workers, appears not to care about overseas workplaces that are producing children for Australians. Because how can the workplace of a slave ever be safe? Section 20 of the Surrogacy Act, in conjunction with the making of parentage orders, provides that birth siblings should be kept together. A birth sibling is defined as any brother or sister of the child who is born as a result of the same pregnancy as the child. This recognises the reality of IVF processes and the benefits of siblings knowing and growing together. But what of siblings in international commercial surrogacy arrangements? It is established fact that they are sold to the highest bidder. The UN Special Rapporteur on the sale and sexual exploitation of children, including child prostitution, child pornography and other child sexual abuse material, has raised particular concerns about this issue. And again, I quote, "Abusive practices in the context of surrogacy are well documented. Examples include convicted sex offenders from Australia and Israel employing surrogate mothers from India and Thailand, a wealthy Japanese man employing 11 surrogate mothers, leading to the birth of 16 infants in Thailand and India, the abandonment of a surrogacy-born infant with disability in Thailand, and the abandonment or sale of excess surrogate-born infants in twin births in India. Commercial surrogacy networks transfer surrogate mothers, sometimes while pregnant, across national borders in order to evade domestic laws. In one case, Vietnamese women were found and freed by Thai authorities, leading to human trafficking charges in the context of a baby farming scheme. However, abusive practices also occur in purportedly well-regulated commercial surrogacy jurisdictions. For example, 2 prominent surrogacy attorneys were criminally convicted in a baby-selling ring in California, a centre for international commercial surrogacy arrangements. There are real reasons why we have eschewed commercial surrogacy in Australia. And like so many important issues raised by this bill is not engaging with these issues adequately, if at all. This bill, in its original form, added one important protection for birth mothers. It would have included a new Section 6 capital A in the Surrogacy Act. This provides as follows. 6A, rights of birth mother to manage pregnancy and birth. This section applies to a surrogacy arrangement despite anything the parties to the arrangement may have agreed, whether or not in writing. A birth mother has the same rights to manage her pregnancy and birth as any other pregnant women. I served as Deputy Chair of the Birth Trauma Committee. I heard and read and spoke with thousands of women and heard their pain, their distress and their anguish about matters arising out of their pregnancies and birthing experiences. And if it is possible to boil the unique experiences of so many women down to one thread, it was perhaps this: that their trauma had been caused by their lack of agency, because somebody else stepped in to manage their pregnancy, to control their birthing experience, and not them. So I was encouraged when I read Section 6 capital A. A great attempt to give surrogate mothers the very agency which all birthing mothers desire. But now, in this final iteration of the bill, it is gone. Perhaps a recognition that commercial surrogates have no agency. Their wombs are to be used by others, and they are too often, as we have seen, actual slaves or financial slaves. This legislation, especially the provision which would facilitate commercial surrogacy, is simply anti-woman. And even worse, it often recognises the problems which it raises, but makes no real attempts to engage with them. This area of law is complex and nuanced and calls out for real solutions. But this legislation has not delivered and was not saved by yesterday's amendments. Amendments which did not even seek to engage with the real and acknowledged issue of slavery in overseas commercial surrogacy. Slavery cannot be an issue which we fix up in the future at some unnamed date. The Minns government, in supporting this legislation, stands condemned for not dealing with this critically important issue first. I stand here today so disappointed to be part of a parliament which appears to be ignoring the voices of women, ignoring the risks of financial exploitation of prostitutes, and incredibly, which seems to be prepared to ignore real issues of the slavery of women because they are women overseas. By voting for this legislation, the Minns government loses all its claim to be pro-woman or pro-worker. It is demonstrating that it is neither. This bill is opposed by the majority of this community, 85% of respondents to a parliamentary inquiry.
The member's time has expired.